Welcome everyone. I'm going to give folks one more minute to join before we get started. All right, hello everyone. Welcome to the second session of the Environmental Law Institute's Summer School Series, NEPA, ESA, and Fundamentals of Environmental Law. I'm Madison Calhoun, the Senior Manager of Educational Programs here at ELI. We at ELI are so excited to have you here today. I want to take a moment to thank all of our attendees for taking the time to join the webinar. I also want to thank our fantastic panelists who have worked very hard to prepare some wonderful content for you today. I have a couple quick logistical notes before we get started. First, as you hopefully know already, this webinar is part of our summer school series of events. Each summer, ELI convenes a complimentary seminar series that offers an introduction to the legal and policy foundations of environmental protection in the United States. These seminars introduce the audience to the major environmental law statutes. So if you've not already done so already, please register for parts 3 through 8 of summer school. They will take place each Thursday at this time between now and the end of July, except for the week of July 4th, which we will be taking off. Additionally, our products regulation and environmental justice sessions will both be offered in a hybrid format, so they will be taking place in person at ELI in Washington, D.C., and they will be streamed online. I believe we only have a handful of seats left for the in-person component of both events, so please do register quickly if you are interested. For today's event, I'll be handing things over to our moderator shortly. She'll introduce everyone and then hand things over to our panelists who will each give a presentation on an environmental law statute. Jim will be speaking about NEPA, while Lucas will be speaking about the ESA. We do welcome questions throughout the event. If you have any clarifying questions about the panelists' presentations, please do ask them as you think of them so that the panelists can address them in a timely manner. You can just use the Q&A box on Zoom. We'll also be saving plenty of time for an audience Q&A during the last portion of the event, and you can submit your questions through Zoom's Q&A function there as well, and we will be monitoring the chat, but it's a little bit easier if you put your questions in the Q&A box. If you have any issues throughout today's webinar, please send me a direct message or email me at calhoun@eli.org. That's CALHOUN@eli.org. I'm here to make today's event as perfect for you as possible. And with that, I'll turn things over to our lovely moderator, Sherry. As Environmental Justice Policy Director at the North Carolina Conservation Network, Sherry White-Williamson leads the organization's efforts to connect impacted community-led campaigns and organizations with decision makers. Prior to joining the North Carolina Conservation Network, Sherry worked at the U.S. Environmental Protection Agency in the Office of Environmental Justice. In her spare time, Sherry enjoys baking, DIY projects, and playing with her dog. Sherry, I will hand things over to you. Thank you so much, everyone.
Thanks, Madison. It's a pleasure to be here. I'm not going to take a lot of time because I think it's more important that we get to the presentations from our panelists today. But today will be an opportunity for all of us to learn more about two bedrock laws in the Environmental Justice Toolbox, both the National Environmental Policy Act and the Endangered Species Act. I know that some of you are wondering what the connection to EJ could possibly be. But by the end of this discussion, I think you'll all understand that either there is a direct way to make the connection, or sometimes we have to be creative in the work that we do to use these two particular laws. I want you all to listen very intently as you hear things that you have questions about. Please submit your questions online. We'll be monitoring those, and for those that may be relevant to the active discussion, we'll try to ask them during that discussion. But we plan to hold most questions until the very end so that we can have a roundtable discussion and cover most, if not all, of your questions. At this point, I want to introduce our two presenters. Jim McEllish is our presenter, who is a graduate of Yale Law School in 1979. He was an attorney advisor at the Department of Interior's Office of the Solicitor. He's been a litigator in private practice at Dow Lowndes and Albertson, and he has been an ELI senior attorney since 1986. His focus is on land use, water, biodiversity, and energy issues. And he has actually contributed to NEPA regulations chapters to both editions of the ABA's NEPA litigation guide, and he's published a number of works himself. Lucas Rhodes is our representative to talk about ESA today. He's a graduate of Georgetown Law, 2017. I'm trying to give you a few years, Lucas. And he served as the Ferraro Legal Fellow at Public Justice for 1 year doing consumer protection and a variety of other public interest litigation. He's been at NRDC for the past 4 years, and as a staff attorney in the nature program, his work mainly focuses on conservation of native pollinators. In addition to doing a variety of work related to pesticide regulation, he analyzes and responds to regulatory changes under the ESA and also represents NRDC and other groups in lawsuits under the ESA. With that, Jim and Lucas, I will turn the program over to you. Thanks, everyone.
Thank you, Sherry, and welcome to all of you to this edition of ELI's Summer School. We're going to spend time on what I think is one of the most interesting statutes in the environmental law toolbox, and certainly the earliest in the modern environmental statutory evolution in the United States. That's the National Environmental Policy Act, known as NEPA, which was signed into law on the 1st of January, 1970 by President Nixon. Next slide, please. We're going to be talking about both the statute, which is a very short statute. It's only about two and a half pages long. So if you want to actually read the law, this is the one you should select, as opposed to the Clean Air Act or Resource Conservation Recovery Act. It is also written in fairly straightforward, plain language, which is helpful, I think. We'll be spending a good deal of our time on the regulations, and what most lawyers understand to be NEPA is really a creature of the regulations. The regulations were adopted in 1978, although they built on some previous guidelines. And the regulations, I think, were a masterpiece of rulemaking. They too were written in fairly straightforward, plain language. There have been some recent changes we'll talk about. The Trump administration made some rather drastic changes in 2020, and the Biden administration undid some of those changes just this last month to return at least some of the NEPA regulations to the long-standing 1978 regs. So let's go to the next slide, please. As I mentioned, NEPA is really the first statute of the modern environmental lawmaking, environmental decade of the 70s. NEPA signed into law on the 1st of January that year, the Clean Air Act later in the year. Clean Water Act 1972, it had been vetoed a couple of times and was passed over presidential veto in 72. Endangered Species Act, which we'll be talking about, 73. Safe Drinking Water Act, 74. RCRA, which is deals mostly with hazardous wastes and to some extent materials recovery the next year. Toxic Substances Control Act, Surface Mining Act, and many others. Certainly a very active decade of bipartisan lawmaking, but NEPA is the beginning of that. Next slide, please. The primary sponsor of NEPA in the Senate, Senator Henry Jackson, Scoop Jackson, as he was known at the time, had basically two major focuses of his tenure in Washington. One was peacemaking and dealing with Cold War issues, and the other was the environment, and with a particular interest in coastal issues. And Senator Jackson articulated in introducing what became NEPA his purposes, which I think are reflected in the final statute signed into law at the end of that year. That's that the laws that we had really did not address the growing environmental problems of a complex society, economically developing society, one with many problems and issues, possible solutions, but we didn't have the tools, at least the legal tools, to address them. So we hadn't declared a national environmental policy. And keywords here are alternatives, which we'll spend time on today, and anticipating undesirable side effects. Federal agencies and permit applicants always think that what they're engaged in is a good thing, and it may be, but what NEPA enables us to do is look at alternatives and look at undesirable side effects of what may or may not be a good thing. We certainly want to be aware of what those effects are and how to deal with them. Next slide, please. So what does NEPA do? The first thing it does is it declares a national policy. To some extent, this has been a lost focus of people dealing with NEPA because the courts have said that they're not interested in enforcing the policy aspects of the law, just the action forcing aspects of the law. But we'll spend a little bit of time on the national policy. The second was it established an action forcing mechanism, and that is primarily the environmental impact statement and some subsidiary analytic tools that basically compel federal agencies to evaluate and consider alternatives to their proposed actions and the impacts of those actions. NEPA provides for public accountability and participation. It is one of the most democratic small d of the laws that we have. Any of you can participate actively in an environmental impact assessment process, and the federal agency is obliged to take your comments seriously. It creates the Council on Environmental Quality and the Executive Office of the President, and it required at the time an annual report on, so how are we doing with our environment? That report was subsequently discontinued by Act of Congress in the 1990s, but was an initial focus of NEPA. Next slide, please. So what does NEPA authorize and direct? NEPA 102 says the Congress authorizes and directs that to the fullest extent possible, policies, regulations, and laws of the United States shall be interpreted and administered in accordance with the policies set forth in this act. This means that this is a congressionally mandated rule of statutory construction, and it's a direction to anyone in the Department of Energy or the Department of Transportation or the Department of Interior or EPA on how to interpret and administer the other public laws that they are engaged with. And indeed, NEPA Section 105 says that the directions of NEPA are supplemental to the requirements of other laws. So if you look at what NEPA says, is it creates both instructions to federal agency administrators, and it is to some extent a grant of authority because policies, regulations, and public laws are to be interpreted and administered in accordance with the policies in the Act. And I'm not going to spend time on them, but take a look at NEPA 101B. There's a set of 6 policies that are laid out. And if you were trying to write a set of policies today for sustainable development or intergenerational responsibility or widespread sharing of environmental justice, you would be hard pressed to do as well as they did in 1969. The first of those policies is declares the responsibility of each generation to the succeeding generations for protection of the nation's environments. So it's worth thinking about 1021 as a rule of interpretation and administration and a grant of authority. But it's often neglected because the courts have been more interested in the section 1022, which I'll cover in the next slide. Next slide, please. 1022 says all agencies of the federal government shall, and C says include in every recommendation or report for legislation, which has turned out not to be that important, but the agencies shall, with respect to major federal actions significantly affecting the quality of the human environment, a detailed statement. This is the environmental impact statement. So the federal agencies are required to prepare an environmental impact statement anytime they are engaged in a major federal action significantly affecting the quality of the human environment. What's the human environment? It's the environment humans live in. It's the entire environment. It turns out that the entire environment is covered by this provision. What's a major federal action? It's an action by a federal agency that has a significant effect. And that can be a funding decision. It can be the grant of a permit. It can be construction. It can be a new program. But NEPA essentially says, if you're doing it, you have to prepare a detailed statement. And the detailed statement looks at the environmental impact, unavoidable impacts, alternatives, and we'll come back to that, relationship between short-term and long-term uses, irreversible and irretrievable commitments of resources. And subsection E also somewhat redundantly also has a requirement to describe alternatives to courses of action. It's not entirely redundant because the courts have held it explicitly applies to a form of an environmental analysis called environmental assessments, or EAs, which we'll get to. EAs also need to have alternatives as well as the environmental impact statements, EISs. Next slide, please. Okay. Agency roles. NEPA directly applies to every federal agency. So each agency is responsible for carrying out an adherence to the requirements of NEPA, to the Council on Environmental Quality Regulations, and to their own NEPA procedures, regulations, and guidelines, which every agency has. Council on Environmental Quality, CEQ, issued government-wide regulations, the 1978 regulations, which were revised in 2020 and again in 2022 last month. And it has certain other procedures. And the EPA has a special role. Later in 1970, the Committee of Jurisdiction over the EPA wanted to make sure that somebody was overseeing how well EISs were being done. And so they added a requirement which they stuck on to the Clean Air Act, which was the legislative vehicle. And it says the EPA reviews all environmental impact statements and scores them. It says how well the agency do at evaluating the impact. Next slide, please. So one of the reasons we're talking about NEPA is because the federal courts from the very beginning have been extremely active in holding federal agencies accountable to the requirements of the law and regulations. So if agency action occurs and there's dissatisfaction with it, there is often a claim to be made that the agency did not comply with NEPA statute or regulations in sufficiently analyzing the environmental impacts of the action or considering alternatives or mitigating the action. The federal courts have made it clear that they do not enforce substantive compliance with the policies. So while the policies are important as a guide to the agencies themselves, the federal courts will not get involved with whether or not the agency sufficiently satisfied the obligations of current generation to the next generation, or assured the widespread sharing of life's amenities, or made the appropriate trade-off. The federal courts did in the 1970s say they're going to take a hard look at the agency's compliance with the procedures. Did they do it right? Did they analyze what they're supposed to? But they're not going to take a look at the outcomes. The Supreme Court has said NEPA doesn't bar unwise agency decisions, only uninformed agency decisions. Next slide, please. So some of the Supreme Court decisions that still have lasting value and importance are listed here. Kleppe versus Sierra Club case involved cumulative impacts, among others. It referred to the hard look standard, which the lower courts had dealt with. So it's still of importance. Vermont Yankee and Strikers Bay both basically reinforce the concept that the courts are only interested in the procedural aspects. Did the agencies consider alternatives? Did they identify impacts they were supposed to identify? Did they follow the procedures and the regulations? Andrus versus Sierra Club said that the 1978 regulations were entitled to substantial deference by the courts. And so almost all the litigation that we've had over 52 years of NEPA have been whether the agencies followed the requirements of the regulations. And then Robertson versus Methil Valley Citizens Council is a case in the 80s which looked at mitigation, that is offsetting of unavoidable impacts. And the court there said the agencies have to consider it, but they don't have to have a full enforceable mitigation plan in order to pass muster with the procedures. Next slide, please. So I've mentioned the CEQ regulations. There were some early guidelines. The early guidelines had cumulative impacts in them for those of you that are interested in the current debate over how much analysis of cumulative impacts there needs to be. And most of what we think of NEPA requirements are creatures of the 1978 regulations. The 1978 regulations were shopped around. They were signed off on by the Chamber of Commerce, by the environmental organizations, by the public in general, and unbelievably, nobody sued to say that these regulations were unauthorized or didn't comply with the statute. So they've been extremely influential in the development of NEPA jurisprudence and in the case law up till the present day. And we'll get to some of the changes that were made in 2020 at the tail end of the Trump administration, and then the recent changes last month. Next slide, please. So important characteristics of the NEPA regulations. The analytic tool is was contemplated in the statute as being the environmental impact statement. That's the detailed statement. It includes consideration of alternatives, impacts, mitigation of the action, and it's required for major federal actions significantly affecting the quality of the human environment. And agencies prepare an EIS, and then the record of decision says, we've considered all the things we need to consider, and here's what we select. And here's our reasons for selecting the alternative we select. Early on, the regulations provided for, and most agencies widely use a tool called the environmental assessment. That's a shorter public document that basically provides evidence and analysis for determining whether there will be a significant effect on the human environment. And typically, the EA is prepared with the expectation that it will lead to a finding of no significant impact, a FONSI. And so the EA FONSI has become, over time, a somewhat shorter, abbreviated tool. Some of them are still hundreds of pages long, but the idea was that this was a concise tool that if the impacts of the action could be designed in a way that they would not create a significant impact, then you would make a finding of no significant impact and you would not need a full EIS and your decision would be compliant with NEPA. The first on this page is the categorical exclusion. The regulations provide that where an agency, based on its own experience and history, determines that, these actions, changing the color of our traffic signs, for example, in national parks, these don't typically result in a significant impact. They can create a class of actions that they don't need to prepare an environmental assessment or EIS on. The adoption of a categorical exclusion needs to be reviewed by the Council on Environmental Quality, and it's subject to public notice and comment. So you can't suddenly declare all these actions are categorically excluded. There is a process. There's also a requirement in the regulations that even sometimes things that are categorically excluded will still need more analysis if there are extraordinary circumstances. If the traffic signage, results in a huge number of accidents resulting in collisions with endangered species, for example, you might need to do a categorical, or you might need to do an EA or EIS, even if a categorical exclusion applies or could be applied in that instance. Next slide, please. Key elements, scoping. Scoping is the beginning of the EIS process. It's a public process, and it's basically saying, are we considering the right array of alternatives before we launch into the analysis? And what kinds of concerns or effects should we be looking at? If you ever have the opportunity to be involved in scoping, take it. It's always required for an EIS. It's often done for an EA. There's often some kind of way to think of alternatives that you might want to have considered that the agency might not have thought of, or impacts that you might think they need to look at. It may be the agency assumption is no one eats the fish in this waterway, but in fact, you may know that as a matter of practice, as a cultural practice, these fish are eaten at certain times of the year, or certain communities rely on them. Scoping is the opportunity to get involved. Identification of alternatives. The regulations in 1978 called them the heart of the NEPA analysis. In 2020, the Trump administration struck the words heart of the NEPA analysis. Some say, did this take the heart out of the NEPA analysis? It didn't change the requirement to do alternatives, however. So it's important to think of alternatives as key. Public participation is extremely important. The agency has a duty to deal with every public comment in a substantive way. They can do it in groups. They get 75 comments that say the same thing. You can deal with one response, but you can't say, thank you for your comment, we don't care. As long as the comment has some substantive aspect to it, pointing out the use of the consumption of fish, or that signage isn't appropriate in all places, the agency has a responsibility to address it. Whether or not you're represented by a high-priced, big-time law firm, And in fact, public participation I've seen in my history lead to selection of alternative that the agency hadn't started with. I've seen it also lead to consideration of or analysis of things the agency hadn't thought of. I'm fond of saying that NEPA is one of the few federal statutes that doesn't presume that the agency is smarter than the public. Finally, mitigation, it's identified and has to be identified where there's a way of mitigating alternatives or the selected action. Next slide, please. So some of the key issues that are still hotly debated and contested and dealt with in the regulations are, how do we deal with cumulative impacts? You know, I just want to open a single coal mine. Am I responsible for all the actions at the coal loading seaport? Am I responsible for global climate change? You might be, or at least you're responsible for the agency, if you need a federal permit, for the agency or the federal actor understanding those impacts in making its decision. Alternatives. There's a question about, does the agency have to consider alternatives that are not within its authority? So, you know, I'm a permitting agency and, you know, I'm responsible for permitting, construction of fossil fuel plants. Well, if there's an energy efficiency alternative, do I have to look at it? NEPA has always said yes, but there's a debate prompted by the last couple rounds of regulation. Expansion or use of more categorical exclusions, certainly always an issue. And occasionally Congress has just legislatively declared certain things categorically excluded. Timber harvesting of a certain size for purposes of dealing with insect damaged forests. Some of these are legislatively or regulatorily categorically excluded. So important to pay attention to it. And some of these other topics, environmental justice is key, and we'll talk about that in the next couple slides, but it's really important to recognize that environmental justice looks at cumulative adverse effects on communities that have had all kinds of effects over their history. And unless you understand the effects of the current action in the context of previous actions, you're not really doing NEPA analysis. Climate change, clearly included in the scope of NEPA analysis, and the big contest in recent years has been, well, how much analysis and how do you do it? And then time limits. You know, often permit applicants or others say, it takes too long. You know, this is supposed to be a concise document. Can't we do it in a couple of years? And I think there's broad agreement that yes, we can. The question is, how firm can those time limits be without impairing the validity of the analysis? Next slide, please. So in 2020, the Trump administration rewrote the NEPA regulations. They're still codified in the same parts of the federal Code of Federal Regulations, but they made some substantial changes. The changes that they made apply to agency actions that were started after September 14th, 2020. So if you're dealing with an agency action that started before that, or with a draft environmental impact statement, or that was scoped before that, you're under the 1978 regs, not the 2020 regulations. The 2020 regulations said we require all agencies to conform to the way we're doing it, our way, and you got to conform your procedures within 12 months, but you have to do it our way beginning immediately September 2020. That had not been the prior approach. The prior approach, agencies were free with CEQ approval to add additional procedures, guidance, and the like. the attempt here with the 2020 rule was to say, this is the way we're going to do it. We don't want you making life more complicated for agencies, applicants, or the law. And then probably most significantly, the rule in 2020 said cumulative and indirect impacts are not what we're interested in. We're only interested in impacts that were caused by or would be caused by the major federal action. So if you didn't cause it in a way that could be analogized to tort causation, you don't need to look at it in the analysis. It also limited what alternatives needed to be looked at, and it redefined purpose and need of the federal action. So you begin with the purpose and need, and the purpose and need then defines, if you define your purpose and need, it defines, in effect, what alternatives will serve that purpose and need and what impacts you need to look at. The Trump administration rule says, in purpose and need, if there's an applicant, that's the one we want to use, which in effect gave the applicant more control than the federal agency did. And it imposed time limits and page limits. There were always time limit and page limit guidelines. The 2020 rule said, no, we want these to be firm unless they're specially waived. A bunch of organizations sued. One of those cases is still live in the Fourth Circuit. Most of the courts found the suit was premature. So watch this space. Next slide, please. So the incoming Biden administration was immediately greeted with, how are we going to deal with all this litigation? Should we just withdraw the prior rule? But the changes were so pervasive, they opted not to take that approach. And so what they did was embark in a two-phase rulemaking. The first phase said, we're going to fix some of the things that we think were worst about the 2020 change, and then we'll deal with other things at leisure, because some of them we might like, or some of them we think actually reflect improvements, or some of them we don't have enough time or capacity to deal with immediately. So the rule that was adopted in April, which became effective in May, made 3 or 4 changes. One is it returned the purpose and need definition to the agency itself, and it redefined reasonable alternatives to the proposed action the way they were in the 1978 version of the regulation. So reasonable alternatives that meet the purpose and need have to be considered in your environmental impact analysis. It restored the definitions of cumulative and indirect effects. So the change in rule, in effect, was, in my view, contrary to almost 50 years of federal case law, which said you have to look at cumulative and indirect impacts. What does it mean if the 2020 rule says, no, you don't? So in effect, they restored the language that was in the 1978 rule. This is important, as I mentioned, because for environmental justice and climate impacts, among others, those are built upon the importance of understanding that the impact of any single federal action does not operate in isolation from all the other things that are going on in the world. It removed the preemption of agency rules. So NEPA processes are a floor, they're not a ceiling. Agencies are free to adopt more strict or additional levels of analysis. And it deferred the time for agency implementation or conformance to the NEPA rules until September 2023. I think the administration is hoping they will have their next phase or phase 2 rule done before that time. We'll see how fast they find themselves able to move. So changes to come. They could restore more of the things from the 1978 regulations, but they could also do other things like address climate change directly 1978 regulations didn't. They could address environmental justice directly. The 1978 regulations didn't. They may address some of the things that the litigants are still having trouble with. The 2020 rules created some presumptions in favor of the agency decision. They put some restrictions on public participation. They said that applicants could prepare their own environmental documents as opposed to the agencies. So we'll see what they do with that. I predict that the next phase of rules will retain some of the timing and management changes. I think having more discipline over how long it takes to do these analysis is likely to be desired by this administration, as it was with the last and as it was indeed in the Obama administration. Next slide, please. I want to mention quickly, some of you will be practicing or operating in states that have their own environmental impact assessment laws. These laws, sometimes little NEPAs or SEPAs, they are not dependent on the federal NEPA. So unlike many of the state clean water or clean air provisions, they don't get approved by EPA. They're not dependent on that. States just chose, mostly in the 1970s, to enact their own laws saying we want our agencies to look at impacts and alternatives. About a third of the states and District of Columbia and Puerto Rico have those provisions. Most of them are so narrow and have so many exceptions that they don't amount to anything. Some of the courts have held that they don't amount to anything. In some cases, they only apply to state construction over a certain threshold. In many cases, even if you have this in your state, it may not be important. Some states have very robust SEPAs, however, and those are, among those are California, Washington State, New York, Montana, Massachusetts, and Hawaii. Some argue there are a couple additional ones that are meaningful, but California, their state CEQA applies to actions of local government. And so almost every action of local government has a CEQA component to it. New York's is not that pervasive. It applies to state actions, but it applies to a lot of state actions. So, watch the space if you're practicing or operating in those places. And I'll leave it here and thank you for indulging me in what I think that was 5 minutes of Lucas's time.
Thanks so much, Jim, and thank you, Sherry, for introducing all this. So yeah, my name is Lucas Rhodes. I'll be talking today a little bit about the Endangered Species Act. So let's dive right in. And I guess before we go any further, I just want to note, I'm an attorney. I often represent NRDC and other clients. I just want to be clear that today I'm here in my personal capacity. Any opinions that I share are my own, not NRDC's or anything like that. So moving to the next slide. Just to give you a quick overview of what I'm going to be talking about today, I want to start off a little bit about the history of the ESA and the importance of the Endangered Species Act. Then I wanted to move into more the meat of it, talk about the core components of species and habitat protections under the ESA. And then I want to move to regulatory changes enacted by President Trump, and then how the Biden administration has dealt with some of those changes. Before we move on, I do want to note this is one of my favorite endangered species, the rusty patch bumblebee, on the right there, and that's the first bee in the continental United States to be listed as an endangered species, and one that I've worked with a lot in my career. Next slide, please. So yeah, the Endangered Species Act, as Jim mentioned, was first enacted in 1973 under the Nixon administration. And so there's a seminal case from the Supreme Court called Tennessee Valley Authority v. Hill from 1978 that I think really, their discussion of the act really encapsulates what Congress had in mind when it enacted the statute. So it said the plain intent of Congress in enacting this statute was to halt and reverse the trends toward species extinction, whatever the cost. This is reflected not only in the stated policies of the Act, but in literally every section of the statute. For the most part, subject to a few amendments, I think that statement holds true today. This is the purposes section of the statute to this day. says purposes of the chapter provide a means whereby the ecosystems upon which listed species depend may be conserved. And it's notable that the Act actually defines the term conserve in a very expansive sense. It's the use of all procedures necessary to bring threatened and endangered species to the point at which their listing is no longer necessary. Moving to the next slide. So we're looking at, basically 50 years of history of the Endangered Species Act at this point. And it's really been, in my view, wildly successful. It's saved species, iconic species like the bald eagle here, others like Florida manatee, gray wolf, American alligator, and others. And 99% of the species listed under its care are still with us today. And so that's really a huge victory. And despite a lot of controversy about the Act that persists to this day, there's constant attempts to weaken the Act through Congress and through regulatory processes. Americans broadly support the Endangered Species Act. So there was a 2019 survey of Americans finding about 80% of Americans support the Endangered Species Act. So that's really good to see that continuing support. And I'd argue that the Endangered Species Act is as important today as it has ever been. We are facing a biodiversity crisis. The UN just a few years ago came out with its finding that about 1 million species are threatened with extinction in coming decades. And so the ESA is a crucial component of protecting species. And so I think it's really critical that we protect these components of protection under the ESA and make sure they're fully implemented and enforced. So moving on, next slide, please. So now moving to the core protections. Again, want to talk about kind of the meat of the statute and talk about how a few of the core protections works. The ESA is pretty broad. I'm not going to get into every single detail, but I want to talk about a few of them. So the key agencies that we're going to be talking about here are the U.S. Fish and Wildlife Service in the Department of Interior, and then the National Marine Fisheries Service, or NIMFS, which is within the Department of Commerce. So the thing to remember here is that the U.S. Fish and Wildlife Service has jurisdiction over terrestrial species, whereas the National Marine Fisheries Service has jurisdiction over marine species. And next slide, please. So by and large, these protections really begin with the listing process under Section 4 of the ESA. And so, depending on where the species occurs, either the Fish and Wildlife Service or NIMFS will consider whether to designate a species as either endangered or threatened. So an endangered species is any species which is in danger of extinction throughout all or a significant portion of its range. Threatened is any species which is likely to become an endangered species within the foreseeable future. And so, as you can see, kind of the endangered species are under a little bit more duress, much closer to the precipice of extinction. Threatened species is something where we're saying there are going to be serious issues down the road. This species is already experiencing significant threats, and so we'll talk a little bit later about kind of the distinction between those designations. But when the services are considering whether to list a species as endangered or threatened, they really look at 5 specific statutory factors that are all focused really on the needs of the species. So these are the present or threatened destruction of the habitat, overutilization for commercial, recreational purposes, disease or predation, the inadequacy of existing regulatory mechanisms, and just any other factors that are affecting its continued existence. And so what's notably absent from those 5 factors is any kind of economic analysis. The Fish and Wildlife Service or NIMFS cannot decline to list a species because of potential economic ramifications of listing. Next slide, please. So this is probably the most well-known protection under the Endangered Species Act, and that's called the take prohibition. So the ESA, the statute itself prohibits take of only endangered species. So take is a very broad term. It means to kill a species, but it also means to, harass, harm, pursue, hunt, all of these other things. You can't go out and do anything that really impacts an endangered species in the wild. And that applies to intentional actions as well as incidental actions. So notably, under the statute, this take prohibition does not apply automatically to threatened species. Next slide, please. So for threatened species, the Act states that the services can issue regulations that they deem necessary and advisable to provide for the conservation of such species. So basically that means it's up to their discretion to decide, what protections are necessary to protect the species. So for decades, pretty much since the enactment of the ESA, the Fish and Wildlife Service has extended all take protections that apply to endangered species to threatened species. NIMFS has taken a different approach, a lot fewer species under their jurisdiction. So what they do is whenever they list a species, they promulgate what's called a 4D rule. And so this is a more species specific regulation stating what kinds of take are barred under the statute. So again, that's a distinction between threatened and endangered species, and then also a distinction between how Fish and Wildlife treats it versus NIMFS. And that's going to come into play later when we talk about some of the changes enacted by the Trump administration. And to be clear, the Fish and Wildlife Service, though it extends those take protections to all threatened species automatically, it can always enact a species-specific 4D rule which overrides those automatic protections. So for example, if the Fish and Wildlife Service lists a terrestrial species as threatened, and it thinks that certain activities, for example, wind development, need to be exempted, so wind developers are not necessarily violating the take prohibition by operation of a wind facility, they could promulgate a species-specific 4D rule saying take is generally prohibited, but wind facilities are not liable for take if they follow certain guidelines. So that's the kind of thing the Fish and Wildlife Service can still do. And next slide, please. So there are also the statute permits the services to allow certain types of take under certain circumstances. And there are two kind of big categories of that. The first are experimental populations. So basically, this is where the Fish and Wildlife Service or some other entity is maybe a captive breeding program doing things to introduce a species into a particular area. And so if you were to do that without going through the 10J process, you could be violating the take prohibition by trapping a wild endangered species or breeding them in captivity or anything like that. That would all constitute take without going through this process. But if the Fish and Wildlife Services issue a 10J rule, people can do those kinds of activities and introduce species to enhance their conservation as long as they stay within the bounds of those regulations. And the other big exception are what are called incidental take permits. So, again, going back to the wind facility example, if I'm operating a wind facility and I know that by operating the facility, I'm going to I'm probably going to take endangered species, I can apply for an incidental take permit to prevent liability for those taking incidents. But by doing that, I have to provide a habitat conservation plan, which outlines kind of all of the efforts that I'm going to make to minimize effects to endangered to listed species, make sure funding is available to take those conservation measures and all things like that. And so then the Fish and Wildlife Service, or NIMFS, will grant that based on a number of factors. But the big standard is that they have to decide that granting the permit will not appreciably reduce the likelihood of the survival and recovery of the species. So basically, they're going to say, sure, you can do this otherwise lawful activity. We realize it's going to have some impact on individuals of the species, but we don't really think it's going to be appreciably impact the survival or recovery. So those are two exceptions to that take prohibition under Section 10 of the Act. And next slide, please. So now I want to talk a little bit about designation of critical habitat. And so critical habitat, generally speaking, are designated areas designated by the services that certain protections apply to, which I'll get to momentarily. So just in terms of timing, so the services have to designate critical habitat to the maximum extent prudent and determinable at the time they list a species. So from that statutory provision, you can see there are two exceptions to this requirement. So the first is where designation would not be prudent. Basically, the regulations have defined this as essentially where designating critical habitat would not provide a conservation benefit for the species. So the classic example is if you were to list some terrestrial species that's limited to a very narrow area, and if you were to designate critical habitat and publish this map of critical habitat, you would be increasing the chance that someone is going to go out and kill that species. So, hunting, picking plants, things like that. You don't want to provide a map for those for poaching. So in that circumstance, that would not be prudent to designate critical habitat. The other exception is when critical habitat is not determinable, and this is basically if the service doesn't have enough information at the time a species is listed to identify critical habitat and designate it, they can delay the deadline by 1 year. But ultimately, the services have to designate critical habitat to the maximum extent prudent. Just a note that this is always determined on the basis of the best scientific data available, and after taking into consideration the economic impact of critical habitat designation. So this is another distinction between critical habitat and listing. When you're listing a species, the services clearly cannot consider economic factors. When they're designating critical habitat, they have to. One more thing to note is that once, if the services find that critical habitat is both prudent and determinable for a species, so that means generally, they're going to designate habitat, they can still exclude specific areas of that habitat from designation based on a determination that basically the benefits of designating the habitat are outweighed by the costs of designating that habitat. But again, that's much more, area specific. So now to go back to kind of what is critical habitat, how are the services determining these areas? So critical habitat is divided into two areas. One is occupied habitat, so species or areas where the species exists, and then unoccupied habitat, areas where the species does not exist. So occupied habitat can be designated when it has the physical or biological features that are essential for the conservation of the species. Unoccupied habitat doesn't have to contain specific features, but it must be generally essential for the conservation of the species. And next slide, please. Sorry, next slide again. And so now we're going to move to the interagency consultation requirement, and this is under Section 7 of the Act. So this section of the statute directs that all federal agencies, not just Fish and Wildlife Service and NIMS, that all federal agencies ensure that any action authorized, funded, or carried out by the agency is not likely to jeopardize the continued existence of species or result in the destruction or adverse modification of critical habitat. So these are two substantive standards that agencies must ensure are not violated: the likely to jeopardize and destroy or adversely modify critical habitat. And this destruction of or adverse modification of critical habitat is really the principal protection for critical habitat. If you have critical habitat designated on private property, that typically isn't going to affect workings on the property unless there is a federal hook, some kind of federal permit involved, which I'll talk about a little bit momentarily. So I said there were those two, thank you. There are those two substantive guarantees under Section 7. So the question is, how do agencies have to ensure that they don't violate those substantive guarantees? And the answer is through interagency consultation with the relevant service, either Fish and Wildlife Service or NIMFS. And so this is basically kind of a series of triggers and determinations made by the agency to ensure that their actions don't have these prescribed effects. So it starts with the question, is there a federal action here? As I said before, private actions that have no nexus with any federal permitting, funding, anything like that are not subject to the Section 7 consultation requirement. So if there's no federal action, there's no consultation required. If there is a federal action, the question is, what impact is that action going to have on listed species? And the first trigger is the may affect threshold. So this is extraordinarily low threshold, really any effect whatsoever, whether it's beneficial, adverse, that's going to trigger this consultation requirement. You have to do some form of consultation. Now, again, if it's not going to affect any species, no consultation is required. Now, the second question is, if the action may affect listed species, is it likely to adversely affect listed species or their critical habitat? If the action agency, so this is the agency that is actually performing the action that triggers this process, if they determine that it will not, that ends consultation so long as the service or NIMFS concur in that judgment. And then if they decide that the action agency determines that it is likely to adversely affect species or habitat, that triggers formal consultation with the services. And so this is a process where the Fish and Wildlife Service or NIMFS will then prepare a biological opinion, which answers the question, is this action likely to jeopardize listed species or destroy or adversely modify critical habitat? So if the answer is yes, that consulting agency, either the services or NIMFS, have to recommend reasonable and prudent measures to avoid those adverse effects, avoid that violating that jeopardy standard. If not, if they make a no jeopardy determination, the action can continue as proposed. So we've talked about two kind of prohibitions. One is the take prohibition, and then we talked about interagency consultation. And in both circumstances, the services are making a determination that certain activities are or are not permissible under relevant standards. And so in the consultation context, if the Fish and Wildlife Service determines that a particular project is likely to jeopardize the existence of a species, like I said, they have to recommend reasonable and prudent measures to avoid that result. And under Section 10, Fish and Wildlife Service is determining whether granting an incidental take permit is going to appreciably impact the survival or recovery of the species. And so if those standards are triggered, there are two ways for a project proponent to ensure that they comply with those standards. They can either mitigate the project's impact. So these are kind of on-site changes, going back to the wind energy facility example. For example, the facility could move away from a ridge to avoid bird impacts. They could install lighting that reduces the likelihood of bird impacts. They could do other things at the facility. If they're not able to satisfy the statutory standards using those on-site impacts, they can use what's called conservation banking. So what this is basically, if I'm a landowner who wants to do conservation actions on my land, preserve it, maintain it, and manage it for particular endangered species, I can apply to the Fish and Wildlife Service for conservation banking, like points, basically. And so once the Fish and Wildlife Service looks at my property, says, yes, you're doing these actions to conserve this species, they'll award these conservation credits to me. and then a project proponent who needs to mitigate the impacts of their project can purchase those products from me. And so in this sense, that wind facility who couldn't quite meet the statutory standard can fund conservation activities at another place in order to meet the statutory standard. But this is all, of course, subject to approval by NIMS and the Fish and Wildlife Service. So next slide, please. Citizen enforcement. So one thing that is, I think, unique about the Endangered Species Act and really critical is that it has an extraordinarily broad citizen suit provision, which means that civil society organizations, individuals play a huge role in enforcing these protections. So this, allows organizations like NRDC to sue to make sure that the Fish and Wildlife Service lists species on time, make sure they designate critical habitat and things like that. It also allows any individual to either sue the services to make sure that the services are addressing illegal take that's occurring, or it could even, so if you see your neighbor is taking endangered species, you could bring a lawsuit under the citizen suit provision of the Endangered Species Act to stop that activity. So the public has a huge role in enforcing the act, and I think this is particularly critical from an environmental justice perspective. So environmental justice considerations aren't explicitly incorporated into the act, but as Sherry said earlier, this is an opportunity to be a little bit more creative with applying an environmental statute and using it in ways that advance environmental justice principles. So one possible example of that is I do a lot of pesticide litigation, and the use of pesticides nationwide places particularly farm workers who are predominantly Latin American, predominantly low income, and generally disadvantaged. They are particularly susceptible to the effects of pesticide exposure. They're often the people applying pesticides and living and working in the areas where pesticides are applied. And so NRDC and other groups filed a lawsuit against the Environmental Protection Agency to enforce the endangered species requirements for EPA's approval of glyphosate, which has been shown to cause non-Hodgkin's lymphoma. You may have heard about the litigation against Bayer. That's separate from ours. But the idea here is that you can bring a lawsuit under the citizen suit provision to stop activity that has these impacts on these vulnerable populations. Now, the cause of action there is EPA's failure to consult on the impacts of that action on endangered species. So that's the substantive cause of action under the Act, but it can have much broader implications for environmental justice. All right, so moving on to the Trump regulatory changes. So the Trump administration enacted basically 5 distinct regulations that made dozens of changes to the way that the Endangered Species Act is implemented. I'm not going to go through all of those. I'm going to just kind of give you a flavor of some of the most important ones in my eyes, and I'll flag as we go along how the Biden administration has now reacted to those changes. So first, there were a suite of changes to critical habitat protections. And so that shows you that critical habitat designation is definitely one of the more controversial provisions of the Act, particularly because critical habitat can be designated on private land, can impact property rights, and things like that. So there definitely have been efforts, particularly under the Trump administration, to narrow the scope of those protections. So next slide, please. So one is a change to the not prudent exception, which I explained a little bit before. This is a wall of text that you don't need to read. But the point I want to make is that the Trump administration changed the regulation defining not prudent to make it easier for the agencies to find designation not prudent, ultimately resulting in no habitat protections for threatened species. Next slide, please. So then the other point is I pointed out the distinction between occupied and unoccupied critical habitat earlier. So previously, when the services were considering whether to designate habitat, they basically looked at those together. You say, you know, this proportion of unoccupied habitat and this portion of occupied habitat are really what the species needs, so we're going to designate those areas. The regulations newly require that the services only designate unoccupied habitat if the occupied habitat is basically insufficient to protect the species. And so this kind of, from my perspective, unnecessarily ties the agency's hands. They should be able to be flexible with habitat protection to make sure it's both effective and efficient, and just this tied their hands in an unnecessary way. Next slide, please. Oops. So there's the two. That's basically again a wall of text that says what I just summarized. Next slide, please. And so then next, the Trump administration defined the term destruction or adverse modification. So this is the standard under the Section 7 consultation that I talked about earlier. This is the standard for destruction of critical habitat. And next slide, please. So basically, the services added this phrase "as a whole" into the definition of destruction or adverse modification. And so they're saying that it only destroys or adversely modifies habitat where it appreciably diminishes the value of critical habitat as a whole for the conservation of species. And the concern here is that this allows kind of piecemeal degradation of habitat, where you're looking at, sure, this logging project destroys one piece of a much larger area of critical habitat, but if you look at it in isolation, it's really not appreciably diminishing critical habitat as a whole, and so that really made explicit this allowance for piecemeal degradation of habitat. Next slide, please. So the Trump administration also expanded these area-specific 4B2 exemptions that I mentioned earlier. So this is after the services decide that critical habitat should be designated, but then they can say in certain areas, well, we think the benefits are outweighed by the costs of designating in this particular area. Next slide, please. And basically what they did was sort of give industry an outsized role in the decision whether to exempt particular areas. And it also opened up those exemptions on federal land, which historically had not been subject to these exemptions. So I won't go into too much detail there. There were a lot of regulatory changes within that rule, but again, just really expanded this exemption. What I'll note is that the Biden administration has already committed to rescinding that rule in its entirety. And so that's one of the biggest actions the Biden administration has undertaken so far. Next slide, please. So next, the Trump administration defined habitat for the first time under critical habitat regulations. Next slide, please. This is significant because of a Supreme Court case from 2019 called Weyerhaeuser v. Fish and Wildlife Service, where basically the Supreme Court said that in order for the services to designate an area as critical habitat, that area must first be habitat for the species. And so the Supreme Court left open the question, what does it mean for an area to be habitat? But they simply said it has to be habitat. And that's where this rule came in. Next slide, please. So they defined habitat to say the setting that currently or periodically contains the resources and conditions necessary to support one or more life processes of a species. And so really this definition is contingent on the current ability of an area to support a species at some time. And so when you think about how that works, that really, again, unnecessarily ties the service's hands in designating critical habitat. So for example, you have a lot of species that are endangered or threatened precisely because they don't have suitable habitat. So if you want to protect habitat that contains a lot of the features that the species needs, but maybe not all of them, it's possible under this definition that that area would not constitute habitat and therefore couldn't be designated. Similar in the face of climate change, you have shifting habitats, and this new definition really tied the service's hands. It doesn't allow them to proactively designate critical habitat that is going to be suitable in the future. Again, this is one that the Biden administration is already committed to rescinding. Next slide, please. So these are a few changes that the Trump administration made to the listing process. So the first, next slide, please, is defining for the first time the foreseeable future. So we talked earlier about the definition of a threatened species is one that's going to become endangered in the foreseeable future. And so this new definition kind of raised the bar and made it more difficult for the services to determine that a species is threatened. Next slide, please. So here, we talked about earlier about how the listing, the services cannot consider economic factors when listing species. And for a long time, the regulations have specifically reflected that. And they said, the secretary can make listing decisions based on this information without reference to possible economic impacts. And what the Trump administration did is they didn't explicitly allow consideration of economic impacts. That would clearly violate the ESA. But they removed this without reference to possible economic and other impacts. And the concern here was that it was going to allow these economic considerations to sort of infect the listing process. And what the service said was that it wanted to prepare environmental impacts or economic impact statements and share them with the public because people might be interested. But again, the concern is that this is really going to actually affect decisions. But now the Biden administration has again committed to rescinding that and restoring the original regulatory text that explicitly forbids consideration of economic factors. Okay, and then finally, the Trump administration, I talked before about how the Fish and Wildlife Service has always applied the take prohibition for endangered species, has automatically applied those protections to threatened species. The Trump administration repealed that, which basically the only effect of that would be if the Fish and Wildlife Service listed a species as threatened, didn't promulgate a species specific 4D rule, the species would be without any kind of take protection. And so again, this just weakened protections for threatened species. And this is another one that the Biden administration has committed to repealing. All right, so I talked about some of these. I flagged those first four that the Biden administration is already going to repeal. It is a little bit open-ended about whether the Biden administration is going to rescind other rollbacks enacted by the Trump administration. Specifically, they've said that they intend to revise the definition of effects of the action. So effects of the action is relevant when we're talking about interagency consultation and what kind of, what aspects of an action the services have to consider when they are finding whether an action satisfies the jeopardy adverse modification standard. So we don't know what the Biden administration is going to do there yet, but it looks like they're going to take a look at that. And then just, I think, earlier this week, the Biden administration introduced or proposed a new regulation that would allow, that clarifies that the services can allow introduction of experimental populations of species into outside the historic range of species. So this is important because it really feeds into consideration of climate change in species protection. Lots of species, their ranges are shifting, shifting northward, shifting higher altitudes. And so this acknowledges that in order to save some species, in order to conserve them, we may need to introduce them into areas where they did not historically occupy. And so that's an interesting rule that is going through notice and comment right now. Okay, and with that, I will turn it over to any questions.
Thanks, Jim and Lucas. You got a bunch of great questions here that I hope we can get to a lot of those. And I'm going to kick it off with a very direct one, and this one can go to both of you. Can you shed some light on standing as related to ESA and NEPA processes? For example, do plants and animals have standing?
So in general, under US law, plants and animals do not have standing. So standing needs to be a legally recognized entity, normally a human being or a corporate entity, and has to have suffered injury that is recognized in law. So thus far, the US courts have been consistent in not granting standing directly to rivers or plants or the like. However, standing is usually based on the existence of some kind of injury to an entity, and often a major federal action or federal action of some kind will result in an injury. And if there is a potential NEPA violation, the courts will hear the NEPA claim under the Administrative Procedures Act. But it's in order to vindicate the rights of the human beings bringing the action. And Lucas, you can add on the ESA if you wish.
Sure. Yeah. I mean, I think really all of that applies to the ESA as well. Typically, in cases where we're challenging actions under the Endangered Species Act to satisfy standing, because we're a membership organization, we have our members submit declarations to the court saying how they are interested in particular species. And so it's that injury to their interest in the environment, their interest in species, that forms the basis for standing. And I would say, standing can be a really huge hurdle, particularly in Endangered Species Act cases, for environmental litigants like NRDC. Particularly, the DC Circuit has erected some serious barriers to standing, and talking about kind of what kinds of injuries are cognizable and how you link that injury to agency action. So it can be a really huge barrier to standing to establish that these federal actions impact the environmental interests that are cognizable.
Thanks for that. I'm going to go back and forth since we've got a bunch of questions on both sides. So Jim, this one is for you. And the question is, and I'm going to try to combine those that I can. Has NEPA been weaponized by groups with non-environmental interests, and are there any tensions with those interests in broader environmental efforts?
I don't like to think of it as weaponized. I think the statute basically provides a set of processes that apply to federal agencies. And if you've suffered an injury because of an alleged failure by a federal agency to do what it's supposed to do, then you have every incentive to participate in the process and to file suit if it makes sense. It can be used by people who don't primarily have an environmental interest, but I think it's basically a rule that or a set of legal rules that are there for all of us.
Thanks for that. And Lucas, the next one is for you. And the question is, what constitutes a federal action or the effects of a federal action for ESA? For example, assume the only federal permit needed for a new chemical plant is a 404 permit from the Corps for site preparation. How far does the analysis have to extend?
Sure. So it's really, and this is another. It's similar to some of the effects of the action discussion that Jim had earlier under NEPA, where there are efforts to contract the scope of the effects of the action, and it's really the really anything that flows from that permit. So construction and operation of the facility are all going to be considered effects of the action. So that's basically what I would say. Jim, do you have anything to add to that?
I don't know if the standard's different at all for the scope of the Fish and Wildlife Services dealing with the core. Under NEPA, they talk about this as the small handle or large handle issue, which is the action at issue might be the permit. Are you filling a wetland in order to build a facility? How far out do you have to go? And historically, the courts and the agencies have gone pretty far out the stream of dealing with consequential actions. I don't know if they would go to like ultimate purchasers or users of your chemicals, effects on endangered species, as opposed to just, what is the construction of the facility, due to the environment. But I'm less familiar with that.
Yeah, and I think there's definitely more and more people are calling for Fish and Wildlife Service and NIMS to consider things like climate change impacts when we talk about a permit for some kind of facility that's going to have emissions or building a highway, something like that. There's a push to consider these climate change effects on species when undergoing consultation for whatever that initial federal action is. And thus far, that hasn't. I don't think we've gotten there where those kinds of impacts are considered as part of the process, but they're a little bit more proximal to the federal action and the federal involvement in the project.
Next question to you, Jim. Do agencies have to comply with the hard look standard, or is that simply the review court's undertake of the agency decision? Many cases seem to suggest that agencies must take a hard look at the environmental consequences.
So it's really the agencies that have to take the hard look at the environmental impacts of the proposed action and the alternatives. The federal courts are there to ensure that the agencies have actually taken the hard look. So I suppose I could conflate it with the federal courts are looking at the agencies to say, did the agencies take a hard look? So it's the agency's obligation that the courts have to find.
Okay. And the next one to you, Lucas. Does any other governmental instrumentality apply to state?
So no, if we're talking about the trigger for consultation,
Yes, I think so.
Yeah, so it's strictly federal agencies, federal actions that trigger the consultation requirement. Though I am less familiar with state Endangered Species Acts, but there are a lot of state ESAs that could potentially trigger some other review, but I'm not familiar with that.
Well, and did the language also speak to the citizen suit section, which, I think the states would be immune under the 11th Amendment from citizen suit, but other entities, might not be.
Right. Yeah.
Okay. Next question, Jim. Does the consideration of alternatives include the environmental impacts of the alternatives, or only note that alternatives might exist? Also, do the impacts need to be defined a priority in order to be assessed?
Okay, so the requirement is that the agency assess the impacts of the proposed action and of the alternatives. So it's not simply, here's our action with its effects and, oh, there's a bunch of alternatives. we look at the impacts of each of the alternatives because that's what enables us to make a comparison. This is one of the ways in which U.S. environmental impact assessment law, NEPA, is actually more advanced than those in a number of other countries where basically it's confined to the effects of the proposed action. We're actually saying we're going to look at the effects of the alternatives as well, including the no action alternative, which has to be studied. Yes, the alternatives you study and the effects you study are identified at the beginning of the analysis. And that's why scoping is important. So we're going to look at fish. We're going to look at fish consumption. We're going to look at historic effects on an African-American community that has lived in this area for an area. Those things are identified at the beginning of the process. And that gives us the opportunity to do a robust analysis, take comment, and draw conclusions.
Thanks for that. Lucas, for ESA Section 7 consultations, how broad is adversely modified critical habitat in practice?
I'm not sure I fully understand the question. I think generally speaking, I would say the services are pretty permissive in terms of allowing actions to move forward that have limited effect. Again, now we are looking at whether that action appreciably diminishes the value of critical habitat as a whole. It's a fairly permissive standard, and so yeah, I think it's rarely a big impediment to federal actions. I would say that. Also, I want to add to my last, when I was talking about the applicability of that standard to states, I was talking specifically about interagency consultation. So I do think Section 10, or Section 9, take prohibitions, incidental take permits, all of that does apply to state governments or private landowners or anyone like that. What I was saying was specifically interagency consultation.
Thanks for the clarification. Jim, back to you. PennDOT, FHWA have a policy that puts many activities in the excluded category, notwithstanding the element that says substantial public controversy is a reason for a categorical exclusion would not apply. PennDOT, FHWA appear to just apply the exclusion to a category of activities without further analyzing whether there is a reason an EA or EIS should be done. Is this typical?
So the Federal Highway Administration's administration of NEPA is a little bit different because of some of the ways in which Congress had enacted the transportation bills over time. So there's much broader availability of categorical exclusions and of states themselves carrying out the federal obligation because of provisions in federal highway legislation. So there are categorical exclusions that are often applied by state highway agencies that in effect, they are the ones interpreting the categorical exclusion within the confines of the federal statute. I mentioned that there are exceptions to categorical exclusions where there are extraordinary circumstances, and I used endangered species as an example of that. One of the areas where extraordinary circumstances might not exist or be seen to exist is the controversy side. And in many instances, a controversy itself is not sufficient enough to constitute an extraordinary circumstance. So it's possible that PennDOT is legally doing what they're allowed to do, whether or not it's wise and supportive of the public interest. And query, maybe they should be doing an EA or an EIS on the action. But I can't, on the basis of what the questioner says, opine on whether they're outside the bounds of what they're allowed to do within the confines of the federal highway legislation.
Thanks, Jim. Lucas, does the strong citizen suit provisions take accountability off of the secretary itself?
The Secretary, Fish and Wildlife Service and NIMS also have authority to, bring civil and criminal penalties against violators. So I wouldn't say it, takes. I think it does in practice. It's less strictly necessary for the services to be doing enforcement because of the citizen suit provision, but certainly there is still a significant role for the Fish and Wildlife Service and NIMS in enforcing the take prohibition and things like that. So there absolutely is still a responsibility and role with the federal agencies.
Okay, thanks. And this one is more of a specific question for you, Jim. How does an agency's consideration of alternatives under NEPA interact with State Farm Review?
Oh, the administrative law State Farm standards. So State Farm basically says an agency can't come out with a conclusion or an action which was not sufficiently anticipated early in the process to allow the public the opportunity to weigh in on it. So NEPA itself is not the action. The action is the permitting action or the decision of in the record of decision where the agency decides what to do. It's important that the agency's actual action comply with the State Farm standard if that applies. In NEPA, agencies generally not well advised to come up with analysis or alternatives that it never offered for public comment. So that's not a direct State Farm issue, but it's probably a procedural violation of NEPA. So I guess I'm kind of groping my way toward the conclusion that these are parallel concepts, that the agency should identify what it's planning to review, allow comment, and then conclude it, but that's not the same thing as the State Farm standard, which is applicable to the agency action itself, because NEPA is not itself the agency action, it's a procedural tool.
Okay. This is a follow-up to the alternatives question that I asked earlier. Could you comment on merits or demerits of only including no action alternatives for assessing environmental impacts of alternative actions?
So in my view, that's not a good use of NEPA. I can't think of a situation where there's not some alternative other than no action. If you're only offering, we're going to do it our way, the way we designed it in-house at the agency or with the permit application, or we're going to do nothing, and those are the only things we're going to study. There's frequently a lot of space in between those things, issues of timing or different ways of achieving the purpose and need. So, at a minimum, you should have at least one more alternative. And frequently, if it's a complex issue, you could have many alternatives. I've seen actions with as many as a dozen alternatives, which may be more than you need and may strain your analytic budget. But if you're only dealing with two, you're setting yourself up for inadequate consideration of alternatives, and that sets you up for a lawsuit you don't really want.
Thanks, Jim. Lucas, you opened a can of worms in talking about citizen suits. So I've got a number of questions in that area, and I'm going to try to summarize it into 3 or 4 points that you can address. One has to do with the use of purple loose leaf control with herbicides by federal agencies and on federal jurisdictional lands, and wondering if that's a case for a lawsuit or is standing necessary. And then the other question having to do with citizen suits asks what happens to a pending administrative complaint? Can the agency intervene? What if the agency recently took action and an administrative order is being tracked for compliance? Could a state agency take action to preempt or prevent a federal agency action? I know that's a lot all in one, but could you spend some time talking about citizen suits?
Sure. So going to the loose strife, so is the question basically like if there's loose strife control that is you think is harming an endangered species?
Yes.
Could you?
Could it be used as a citizen suit, or would standing be necessary to do that?
So conceivably, yes. I want to be a little bit careful about how I answer this question. I think conceivably, if someone is applying pesticides in a way that harms endangered species, that could be take. In any citizen suit provision, standing is going to be a hurdle. You would have to show that you are injured in some way and satisfy the requirements of Article 3 standing. So that's what I would say there. So in terms of the second question, so if you were to bring a citizen suit against someone who you believe to be violating the ESA and in Fish and Wildlife Service or NIMS is separately diligently prosecuting that violation, so your lawsuit would be essentially, I don't know what the technical term would be in that circumstance, but it would be basically preempted, where your lawsuit would be put aside while that investigation and that enforcement proceeds. Does that answer all of the questions?
I believe it's I believe that does answer. If that doesn't, if that person will put something in the text, we'll try to answer the rest of that question. Jim, for states that have SEPAs, will they have to complete both a NEPA and a SEPA requirement?
So yes, they will if the action triggers both statutes independently. So many actions in, say, Washington State or California, say, might trigger each one because they require state permit as well as a federal permit action. That does not mean you have to do two separate documents. Frequently, the states that are in this situation have agreements or enter into agreements where they become cooperating agencies and can prepare a unified document which satisfies the requirements of both the federal and the state environmental impact assessment law.
Thanks, Jim. Lucas, one of the viewers is asking for a few examples describing the revisions to the effects of the action definition. Could you do that?
So the one that I can think of that was particularly impactful is that the Trump regulations specifically excluded ongoing effects from the effects of the action. And so basically the example I can think of is like if the agency action at issue is like the reauthorization of a dam, like an operating permit at a dam, all of the effects that have been occurring at the dam on endangered species and are ongoing would be not considered part of the effects of the action and not considered in the consultation process. So that's a big one. But I would have to look back at the specifics of how else they changed it, but the upshot is that it definitely, those regulatory changes narrowed the scope of the effects of the action.
Thanks, Lucas. And this is one for both of you. Where do these two laws intersect with hydropower the most?
I don't know where to start. Hydropower, like relicensing?
That is the question. If the person who submitted it is still online and wants to put some clarification in the chat, then we can try and answer from a NEPA perspective. Lucas, do you have any thoughts on that?
Yeah, I think so. I think hydropower operation and development, certainly the building of dams implicates both Section 7 and Section 10. In a lot of circumstances, there is extensive litigation about dams and other actions in the Pacific Northwest affecting salmon. The TVA v. Hill, the case that I mentioned from 1978 was actually about the construction of a dam in Tennessee that I believe it was the snail darter in that case. The fish was discovered, and the operation of the dam or the construction of the dam was called into question. So certainly the construction and operation of dams very frequently implicates, like I said, both consultation and the take prohibition. So there's definitely a lot of intersection there.
And NEPA would apply whenever there's a major federal action. So changes in operation or construction or licensing or permitting would apply. And frequently, many environmental instances in all areas of both ESA and NEPA are involved, and as well as Clean Water Act or other provisions of law.
Thanks both. And Jim, this is back to you. Were activities related to ARPA and COVID funding exempted from NEPA analysis?
I am not sure. I have some vague recollection that that there were provisions dealing with Treasury dispersing money that was not subject to NEPA at the handing out the money stage, but I haven't followed it closely enough to know.
Okay. A question for you, Lucas. Are population sizes or densities considered when effective breeding individuals limit populations? That is, a wolf pack of 20 individuals may only have one breeding pair, or a very patchy distribution of cinquefoil can limit an obligate insect population dependent on that plant.
So I certainly don't know specifically. I think that is certainly something the services would consider when talking about the viability of populations, whether they're threatened with extinction. Yeah, you could have 100 individuals if there's one breeding pair or one female in that group. That's going to be considered in whether that population is threatened with extinction, I would say. So at that very high level, I would say yes, those things are generally considered or could be considered.
Thanks. And this is a cumulative impacts question. Have you seen good examples of how cumulative impacts have been assessed? What information made cumulative impacts determination successful? Have you seen this done successfully in the context of climate change impacts?
I need to think about that in terms of successful a little bit. To some degree, I follow cumulative impacts issues more in the litigation context where someone is alleging that it has not been done or not been done well enough, as opposed to reading a lot of EISs where it may have been done particularly well. Almost all the climate change analysis is based on cumulative impacts because almost no major federal action itself will have a very large effect on climate change. So essentially almost all of the last 10 years of evaluations of fossil fuel development and the like have involved understandings or assessment of cumulative impacts, some of which have led to decisions, not to proceed with leasing or not to permit a particular activity to continue. I also recall in the mining context, hard rock mining context, occasionally the Interior Department has not looked at one mine at a time, but has looked at a number of small scale gold mines in the same region of Alaska, and that in effect is a better way of understanding the impacts on salmon biology and the operation of the system than treating each proposal as a separate independent proposal. So I think cumulative impacts has always been hard to do, and that in a way has accounted for its unpopularity among permit applicants and to some degree within federal agencies. But it's essential because we can't understand the environment that we're operating in unless we're able to understand how things are connected to one another, and not just that they are connected to one another.
Thanks, Jim. This one is for you, Lucas. What happens after a project goes through a Section 7 consultation and the relevant agency issues a biological opinion?
So basically, at that point, the biological opinion is going to make a determination about either the project does cause jeopardy or destruction or adverse modification. If they make that determination, then they're going to recommend reasonable and prudent measures to mitigate those effects for the other agency, the action agency, to consider. And so either the agency can implement those measures in order to avoid jeopardy or adverse modification, or in the case where a jeopardy conclusion is reached, the action agency isn't willing to mitigate the effects of the action, the action agency can seek an exemption from the Endangered Species Committee. I didn't go into that, and frankly, I'm not extremely well versed in that process, but you can seek an exemption from basically seek permission to move forward despite jeopardy or adverse modification. So that's what would happen if there was an affirmative finding in the biological opinion. If there was a negative finding in the biological opinion, basically whatever the action at issue is could move forward as proposed. Consultation is complete. The action agency has satisfied their procedural requirements by going through consultation, and because the consulting agency has said that they don't violate those substantive guarantees, jeopardy and adverse modification, the substantive guarantee, they're okay there as well, and so that action can move forward.
Thanks, Lucas. And this is another one for you. New species are introduced almost daily, most called invasives, but some are introduced to counter the effects of invasives. What role do the courts plan in regulating those species when they can limit the habitat of an endangered native species? Does the Endangered Species Act address this in any way?
So I think it could, if you had a federal program that was actively introducing an invasive species in order to address some issue, that's the kind of program that could trigger consultation, and look at, well, what effect is this program having on endangered species? That's kind of the I think the best answer I have. I don't know if Jim, yeah.
This actually reminds me that NEPA has a role to play there too. A decade ago, the government was looking at introducing exotic species of oysters into the Chesapeake Bay in order to deal with the decline of the native oyster, which was succumbing to disease. And there was an environmental impact statement process that went through the process. And it's a favorite example of mine because an engineer working on his own time read all the tables to the environmental impact statement and found that the Corps of Engineers had made a mathematical error which understated the risk by an order of magnitude. And everybody reviewing it hadn't bothered to read the tables, but it was a key oversight or problem, and an ordinary citizen identified the problem, and the Corps went, oops, we're going to go back and redo it, and they ended up withdrawing the EIS, and the decision did not proceed.
Thanks, Jim and Lucas. And you all are doing a fantastic job getting to these questions. We may actually get them all done by the time that your time is up. So we've only got a few more. So let me see if we can get through those real quickly. Lucas, how does the ESA apply to private entities or individual property owners?
So it depends a little bit on, what section of the act you're looking at. The take prohibition applies to all activities by anyone. So it doesn't matter if you're a government entity, private entity. If you do something that takes an endangered species, you've violated the act. Section 7 consultation is considerably narrower. So if I'm a private landowner and I'm building something in my backyard, 99% of the time, that's not going to trigger any kind of federal action, any kind of federal permit, federal funding, anything like that would trigger consultation obligations. But if I'm a landowner, I'm building something, and in order to do that, I have to fill a wetland and get a Section 404 permit from the Army Corps of Engineers. That permit would trigger consultation requirements, and the Army Corps would have to go through interagency consultation before issuing that permit. So those are really the main ways. And to go back to critical habitat, because I think this is somewhat of a somewhat misunderstood area. People think that if your property is designated as critical habitat, suddenly it's a nature preserve and you can't do anything with it. And just to be very clear, really the only substantive protection is consultation. So your ability to use your property is only affected to the extent that there is a federal action, or to the extent that that action is actually going to take species, and that's again under Section 10. That's not critical habitat, but modification of critical habitat really only comes into play in the consultation context. So it's only relevant to federal actions.
Okay, it looks like most of the rest of the questions are for ESA or ESA related, Lucas. So I think you're going to be on the hook for a couple of minutes.
Okay.
You mentioned the standard for granting an incidental take permit. Can you repeat that standard and share where that came from, statute or case law?
Yes, let me pull it up again because I don't have it memorized. Sorry. I'm biding time, so I'm saved by the bell for more questions.
Okay, well, let me see if there's anything on here that I can throw to Jim while you're doing that.
I actually just found it.
Okay, great.
So the standard is, and this is only one, there are several factors. This is kind of the main one, is that taking will not appreciably reduce the likelihood of the survival and recovery of the species in the wild, and that is from the statute, section 10.
Thank you. Next question. In what ways did the Trump administration change the Lacey Act, the listing of injurious species, and will those changes persist in the Biden administration?
I don't know. I am not familiar with changes to the Lacey Act. I don't know that there were any, but
Okay.
that is not my area of expertise, unfortunately.
Okay. Can you elaborate on what the threshold is for federal action to be considered significant vis-a-vis impacts to the environment?
So significance is one of those NEPA terms that there used to be a definition, and then the Trump administration folks decided to get rid of the definition, and that significance is basically defined by context and intensity of the action, and there's case law, but it's very site specific to determine what significance is. But context and intensity are the historic provisions that we've relied on in the NEPA regulations over the decades.
Thanks for that. We have 2 questions left, but I see that Madison has come back on, so I'm assuming that our time is up.
Yeah, it's up to you all. If you want to answer them, we can. If not, if you have to go though, that's perfectly okay as well.
Okay, well, let me throw them out and see if anybody wants to grab them then. Does the ESA citizen enforcement statute allow action against state governments? If so, does that raise 11th Amendment concerns? And the other question is, for a project that requires a Section 404 permit for impacts to wetlands or waters of the US, but is not otherwise a federal action, what is the trigger for the development of an EA or EIS? So I guess that's one for each of you, maybe.
You want to go first, Jim?
Mm-hmm.
I'm so sorry. Could you repeat the first question?
Does the ESA citizen enforcement statute allow action against state governments? If so, does that raise 11th Amendment concerns?
So technically they are encompassed under the provisions of the ESA, but it would raise Section 11 concerns in a lot of circumstances, yes. Or, yeah.
Okay. And the other question was, for a project that requires a Section 404 permit for impacts to wetlands or waters of the US, but it's not otherwise a federal action, what is the trigger for the development of an EA or EIS?
Yeah, so the question there is, what is the level of significance, and do you measure only the impact to the waters of the US, or do you measure that of the entire project? And that's been a contested issue over the history of NEPA. NEPA does apply, and because the 404 is a federal action, and the question is it a major federal action with a significant impact on the human environment? Typically, you'd be able to handle it with an EA unless it's a very large or substantial project. But it is a contested issue over time. Do you only look at the 100 yards of impact to the stream bank, or do you look at the project as a whole? Over most of NEPA's history, we looked at the project as a whole.
Thanks, Jim and Lucas. And I'm going to throw this last question to you. I can't resist. How does a young law student pursuing a career in environmental law find success when the presidential administrations are changing the laws so frequently, especially since these laws take a while to be relevant?
Lucas, you had to do this more recently than
I. I would say shifting administration certainly affected where my decision of where to look for jobs in the environmental field. I think, being in an advocacy organization, you can be, engaged in this area, and we have to be very flexible and respond to, if there's an administration that is changing laws in ways that we believe are not good, we're there to defend the existing protections And same goes for if there are positive developments, we're there to defend those changes. So it certainly impacted my decision, and I think that it was a good one to go to an advocacy organization.
I would add, as people are thinking about careers, there are a lot of environmental law jobs in states and cities. They undergo changes in administration too, but you know, there are great environmental experiences to be had and professions to be entered. Also think about agencies that are not EPA or Interior or NOAA, the federal agencies, Department of Energy, Federal Highways, all kinds of agencies, FAA, have environmental opportunities. And so you may find a corner there where you can learn a lot of environmental law and become an expert, even if, you know, you feel like, well, I don't want to join this EPA at this time.
And just in terms of like the laws changing and just kind of understanding the substance, I think like one thing to keep in mind is that we talk about these changes and they are very impactful, but kind of the bones of the law are almost always still there, and you can learn the fundamental components and provisions of the law and understand how it works. And once you have that background, it's much easier to understand how things are shifting and how it impacts things on the ground. So, you know, having a background despite things changing constantly, it's very helpful.
Thanks, Jim and Lucas. It was an honor to be able to moderate a panel with the two of you. And I'm going to turn it back over to you, Madison.
Thank you all so much. I don't have much to add. I just want to give a big thank you to Jim, Lucas, and Sherry for this wonderful discussion and giving our audience so much information about these two statutes. So once again, folks in the audience, register for sessions 3 through 8 if you're interested. We would love to have you. And this recording will be posted on ELI's website. So if you have friends who couldn't make it, please be sure to tell them to check it out. Thank you again and have a great afternoon, everybody.
Thank you all.
Thank you.